We are looking at a shift right now that is fundamentally rewiring the entire legal industry. Artificial intelligence is not some distant hypothetical threat to the legal profession. It is an active, present disruption. Right now, it is dismantling traditional workflows in law firms, courtrooms, and corporate legal departments across the country. This isn't theoretical anymore. It is quantifiable, and it is actively reshaping the practice of law from the ground up. Consider this comprehensive analysis from Goldman Sachs. It reveals a staggering figure. 44% of legal tasks are subject to immediate automation by generative AI systems. And let's be clear, this is not a projection for a decade from now. This is the baseline capability of the technology that is currently being integrated into enterprise software across the sector. Routine drafting, initial discovery review, basic precedent compilation. 44% of the work that is historically defined standard legal practice is actively being handed over to algorithmic processing. So, what exactly does that 44% mean for the 1.3 million practicing attorneys currently operating in the United States? It frames an existential question for the industry. If nearly half of all standard billable tasks can be executed by algorithms in a matter of seconds, the current economic and structural model of the U.S. legal market is standing right on a fault line. The very foundation of the billable hour, a model which has sustained law firms for over a century, is under immediate and unprecedented pressure. To navigate this shifting landscape, we need a clear, authoritative roadmap. First, we will examine the scale of change. Second, we will look at the jobs that are already gone. Third, we will identify what AI absolutely cannot replace. Fourth, we will analyze the firms winning right now. And finally, we will outline exactly what every lawyer must do to ensure their professional survival. Section 1. The Scale of Change. Let's look at what generative AI is actively executing within law firms today. The specific type of work being targeted by these platforms is no longer experimental. Enterprise AI systems like Harvey, Lexis+ AI, and CoCounsel are actively performing first-pass document review, contract drafting, complex legal research, and M&A due diligence at an incredible scale. Think about the traditional workflow for a corporate merger. What used to require a massive team of junior associates camped out in a conference room, billing hundreds of hours to review a dense data room, is now processed by enterprise AI in a matter of minutes. The machine automatically surfaces key clauses, anomalies, and liabilities almost instantly. The traditional grunt work of the legal field has essentially been systematically digitized. The reality on the ground is stark. David Wakeling, a partner at A&O Shearman, which is one of the earliest and most aggressive adopters of this technology, states it plainly. He notes that these agents do in minutes what previously took several hours, adding that they have put their lawyers' brains into their tech stack alongside Harvey's gold standard AI. This represents an entirely new method of delivering legal services. It transforms what was once an unpredictable, highly manual human labor process into a scalable, instantly deployable technological asset. Section 2. Jobs already gone. We are moving past the theory and looking at the immediate human casualties of this integration. For decades, the U.S. law firm has relied heavily on the traditional leverage pyramid. Partnerships hire massive classes of junior associates, assign them high volumes of routine work, and bill the client for the time those associates spend learning the practice. Today, that traditional pyramid is actively compressing. With AI handling the routine discovery and drafting, the base of the pyramid is structurally collapsing. Firms are hiring smaller junior classes. Instead, they are prioritizing lateral, experienced hires who offer immediate strategic value, and they are hunting for highly tech-fluent paralegals. This raises a critical industry crisis. If firms no longer need armies of juniors for document review, the traditional apprenticeship pathway for new law school graduates is rapidly narrowing. We are already seeing the concrete results of this shift. In February 2026, Baker McKenzie cut between 600 and 1,000 business services roles. This encompassed IT, knowledge management, and administrative support, and the firm cited AI integration directly as a primary driver. This stands as the largest AI-attributed reduction in the legal industry to date. The pure administrative support layer, the personnel historically tasked with rote knowledge compilation and formatting, is being permanently erased from the modern law firm's ledger. But as those old roles vanish, a vital new shift is emerging: the rise of the AI wrangler. While pure administrative support shrinks, modern legal departments are aggressively hiring tech-fluent paralegals and junior associates whose primary responsibility is to interact directly with these large language models. These professionals are the ones engineering the prompts. They verify the machine outputs against primary sources, they filter discrepancies, and they pass on a significantly higher volume of refined work up to management. The role of the junior lawyer is shifting entirely from executing rote work to directing, verifying, and refining the AI's output. Section 3. What AI cannot replace. It is time to define the absolute boundaries of artificial intelligence in legal practice. AI is a phenomenally powerful tool, but we must acknowledge that it is deeply flawed and downright dangerous without rigorous human oversight. Current AI models operating in the legal sector maintain about an 82% baseline accuracy. That leaves a 16.7% hallucination rate. Put simply, the system essentially invents facts or fabricates case law 1 out of every 6 times. In a courtroom, a hallucinated precedent is fatal to a case and potentially fatal to a career. Furthermore, an algorithm lacks empathy. It cannot read the nuanced psychological dynamics of a negotiation room, and it possesses no moral compass. It simply cannot replace the core, fundamentally human tenets required to navigate the justice system. What this means is that human value in the legal profession is shifting definitively. AI owns pattern recognition, initial drafting, and massive data ingestion, but human competencies remain completely insulated from automation. Courtroom advocacy, client empathy, ethical judgment, and complex, multivariable legal strategy are domains exclusively held by human practitioners. Your absolute value as a legal professional is moving away from document synthesis and strictly toward high-level strategic reasoning and relationship management. Work that a machine can do renders a professional vulnerable, but work requiring uniquely human judgment renders a professional indispensable. Section 4. The firms winning now. Let's examine how proactive firms are weaponizing this technology today. The financial reality of this adoption is staggering. The legal tech AI market is compounding at a 33.4% annual growth rate. Firms that have instituted a formal, aggressive AI strategy are reporting they are nearly 4 times more likely to experience critical operational benefits than those without one. The technological moat between the early adopters who are actively scaling their capabilities and the latecomers who are still clinging to legacy workflows is widening at a pace we have never seen before. To put some numbers to that widening moat, law firm technology spending surged by 9.7% in 2025. That represents the fastest real growth ever recorded in the legal industry. Firms are racing to deploy these systems, but this deployment creates a massive economic tension. Think about it. If a firm uses an AI platform to complete 10 hours of traditional legal work in just 1 hour, they can no longer bill the client for 10 hours of time. The 90% of legal revenue that is still flowing through the standard hourly rate model is under immense pressure. Because of this, firms are being forced to evolve into alternative fee arrangements or value-based billing to protect their profit margins while delivering vastly faster results to their clients. That 9.7% surge in spending is actively fueling a highly concentrated ecosystem of specialized enterprise agents. Harvey dominates the AmLaw 100 for broad general legal AI and complex drafting. Meanwhile, Lexis+ AI and Thomson Reuters co-counsel are locking down legal research, largely because their models are specifically grounded in verified case law, which heavily mitigates that hallucination risk we discussed earlier. On the corporate side, platforms like Luminance are taking over autonomous contract negotiation for massive enterprise organizations. What we are seeing is not a single novel application. It is a highly specialized multi-tool infrastructure taking root. Looking at the vanguard, A&O Sherman provides the definitive blueprint for successful enterprise integration. They did not just give a few select partners access to a browser-based chatbot. They deployed Harvey globally, scaling it across 4,000 staff members in 43 different jurisdictions. Furthermore, they partnered to build Contract Matrix, a custom generation tool grounded entirely in their own firm-specific historical precedents. By locking the AI within their private data ecosystem, they severely reduced the hallucination risk and transformed off-the-shelf software into a proprietary competitive advantage. Section 5. Whatever lawyer must do. This is the actionable mandate for your professional survival. Survival in this new landscape requires 3 immediate concrete steps. Step 1. You must achieve foundational AI literacy. This means learning the actual mechanics of prompt engineering, understanding exactly how to verify outputs, and integrating tools like CoCounsel or Harvey into your daily routine. Step 2. Reposition your internal value. If your brand at your firm is the person who processes document review quickly, that brand is now officially obsolete. Step 3. Specialize relentlessly. Direct your career trajectory toward complex, judgment-heavy, and relationship-driven practices. Become the trusted advisor, the seasoned litigator, the strategic negotiator. The 2025 Future of Professionals Report delivers a stark, data-backed conclusion for the industry.
They note that as the demand for tech-savvy, adaptable, and interdisciplinary collaboration continues to grow, those professionals not honing their skills may find themselves adrift. Adaptation is no longer an optional pathway for the ambitious. It is the uncompromising baseline requirement for career survival in the modern legal sector.
All of this leaves us with a critical question regarding the regulatory framework of the profession itself. If technological proficiency is now intrinsically linked to accurate legal representation, should bar associations step in and require AI literacy as a mandatory component of continuing legal education? Does an attorney who relies strictly on manual, analog research methodologies in 2026 even meet the ethical duty of competence to their client? Think about the profound implications of that shift. Let me know where you stand on the regulation of this technology. Should bar associations require AI literacy? Comment yes or no below. Thank you for joining me for this explainer, and I will see you next time.